Give the public what they want.
All right, we're good to go.
Okay. Guys, before we get started, I need to read the Ethics Act statement for this subcommittee meeting. It is the duty of subcommittee members to avoid conflicts of interest and appearance of conflicts of interest in performing the duties as a member of the Henry Brocker Inquiry Re Lawyer Participation in Google Screen Pay-Per-Lead Advertising Program Subcommittee of the North Carolina State Bar. Any member of the subcommittee who is aware of a personal conflict or appearance thereof with respect to the matters before the subcommittee should disclose that at this meeting, either now or when it arises. So having said that, Suzanne, I turn it over to you. If everyone did not see the email that we got recently, as in the last hour or so from Suzanne, that included lots of very good edits from Ridley, please pull that up. I would love to acknowledge that my man, Mr. Rand, is a fan of the Oxford comma. So I'm really excited about that. I got an Oxford comma t-shirt for a birthday present a couple of weeks ago. My daughter is now writing for the Daily Tar Heel, and the editors of the Daily Tar Heel are taking out her Oxford commas. No. So there is war on the horizon.
I'm here for you and I'm here for her. I'm not here for them at all. I got no interest in them. I'm here for her and you.
Okay, Suzanne, having said all that, take it away, please, ma'am.
I'm not sure where we want to start. I mean, do we want to just start with the article? I mean, or do we want to talk about the inquiry, how we got here?
Now, I think we're past talking about where we got to, unless we need to repeat all of that for historical record. But I say we just start with the article, unless anyone objects. Okay.
All right. So hopefully everybody got to read the article. Basically, it just goes through and it talks about why it's so hard to write an ethics article about internet advertising or anything really on the internet. It talks about some other journal articles I've written, and then it talks about this specific inquiry and why the ethics committee decided to go ahead and look at this question, which was basically because of our concern about the duty of confidentiality and how important that is. The article talks about the proposed draft and then the comments that we received to the draft. And thanks the viewers, thanks the readers for their comments, and notes the ethics committee's conclusion that we were not going to do a formal ethics opinion on this, but instead we were going to do an article, partly because we had a proposed draft out there and we didn't want to just leave that hanging, and also partly to remind lawyers of their general duties when they're deciding whether to participate in an advertising program. Trying to go through, look at what else it says. Talks about the cloud computing and web management, and then it specifically discusses the Google advertising program, and it sets out some precautions that a lawyer needs to take if they're considering participating in any type of program like this. They have to vet, of course, the company. They have to educate their employees. They have to make sure that they're not inadvertently forming an attorney-client relationship. And a big part of that, as we talked about, I think at the last meeting, is making sure that the people that take the calls are limiting the information that they collect. And they also have a duty to make sure that the program, the advertising program, complies with the Stored Communications Act. And I had an outline, and now it's hidden by all your faces, which I'd rather look at your faces, but that's the gist of it.
So Suzanne, one thing that I think I've asked this question before, I think you've answered it and I think I forgot. But obviously you've written 2 articles on this evolving subject before, but how common is it for the bar to decide to write an article in lieu of issuing an actual opinion?
I think we've done it before, I feel sure.
It's not uncommon.
I'm sorry, what?
It's not unheard of, that's for sure, because we've done it when with the opinion on the handheld device, your own devices, and whether you had to BYOB devices, and whether you had to understand the apps and all that stuff. I think, didn't we just write an article on that?
Probably for the very same reason as this.
And it was, yeah.
I know we write a lot of articles about opinions that are being considered. We write about them while they're being considered. We write about them after they've been adopted. And I think Warren is right. That's one example of where we did an article instead of an opinion. I don't know if we had a draft opinion on that one or not, or if we just jumped to an article. I can't remember.
Well, this subject matter to me, because it is evolving at light speed, seems like it would be more right for articles for the reasons that we're writing this one than other topics. So I was just curious as to overall how often the bar did that. Okay, well, unless anybody has a better idea, I'd like to sort of walk through it. I wasn't organized enough to get you my comments in advance, and some of them overlap, but if we can do that, I think we're in good shape. Unless anybody objects, I'll just walk through my stuff. Is that okay, everybody?
That sounds great to me.
Okay.
Let me pull, I'm trying to pull up that copy.
Starting with the beginning, I was just wondering whether or not we should take out the word your, like catching smoke with bare hands or with your bare hands. I don't really care. I was just bringing it up. And then if we go down 1, 2, 3, 4 paragraphs, where you start, as I noted in my previous article, I was wondering 4 lines down if we needed the word personal to describe a law firm's website. Or
Yeah.
if law firm's website would suffice.
Yeah.
2 lines below that, where we have non-law firm entities, I was wondering if a better way to phrase that might be non-legal entities. Again, don't much care, just sort of word choice thing for you, Suzanne. And then I think Mr. Rand's box is important because it's not just rendered moot. I thought he made really good points there. What does everybody have to say about that? He's talking about the fact that it's not just mootness we need to consider, but it's also relevance and enforceability.
I mean, we did talk, I do talk about that a little bit in the article. The fact that we don't have jurisdiction over these.
And even if we don't have jurisdiction over them, I think the issue there would be, yeah, we may not have jurisdiction over, let's say, AVO, but the lawyer who uses AVO, if they learn they're doing something that's unethical, they can't use AVO anymore for that, whatever that function is. So we can't get AVO, but we could sure tell the lawyer who's using some functionality that makes the lawyer's use of AVO unethical that he can't use it anymore. But that's why we're not. Right.
Well, and I think that's the unique territory that we're in here, because we're not just talking about lawyer conduct. We're talking about lawyer conduct as it relates to third-party platforms, which is unique to this issue. So
I guess I'm just afraid it gets into a rabbit hole if we try to get too much into that topic. itself.
Okay.
For what it's worth,
Um,
I tend to agree with Warren on that, that it's because it is one of those really tough things where, like you said, Gina, we're not talking about we're really talking about the third party platform and its functionality, its design, but it is the lawyer's conduct because the lawyers interacting with and utilizing the platform. And I think it potentially sends a message if we say, well, we can't enforce anything that relates to these third party platforms. I fear that it sends a signal that may not be true, in the sense that we don't enforce something over the third party platform, but we sure could enforce something on the lawyer's participation. That's, the intermediary organizations that we have under Rule 7.4 now. And what this very opinion was attempting to wrestle with, a lawyer's use of a platform that I think all of our initial reactions were, this is just icky, and all that. But of course, we're reaching a different conclusion here. But the point being that I think trying to say that, it's a topic that we really don't have, I guess, jurisdiction over, or we have any ability to enforce any sort of standard. I think that might send an incorrect message to lawyers about their participation.
You know what I was thinking is in the beginning where I talk about the difficulties, and I have it's complex and it's changing, then I was just going to put a number 3, which was that we don't have jurisdiction over these non-legal entities. What do y'all think about that?
That's a good place to put it. It
Brian's
fits-
doing
it fits in there.
the. What,
Yeah,
I just
I
have a
think
hard
it
time doing that. I mean, lawyers use those, self-aggrandizing lists that are done by third-party vendors. We tell them they can't do certain things on those. I mean, they have to take their names off of those lists if they find out they're making false and misleading claims about the lawyer.
I mean, there's a sentence in this
that-
article right now that says, we also need to remember that we do not regulate the actions of non-lawyers. I mean,
Yeah, I think that
but that's it.
I like
That's
that better than saying that that we don't have jurisdiction over this in some way, because we do over the lawyers who engage with this.
So Warren and Brian, would you object to a merged notion of using a number 3 at the top that said the bar has no jurisdiction over the platforms, but does have jurisdiction over the lawyers using the platforms?
That's what I was trying to kind of craft some language on the fly here that says that essentially the state bar's jurisdiction is limited to a lawyer's participation in the platform, but not the platform itself. Something like that.
Different way of saying the same thing. I think that would.
and I'm going to put that as the third difficulty.
Yeah, I think yes, I'd be fine with that.
Me too.
Me 3. Okay, and so my next issue is way down on page 2 in the 1, 2, 3, the third full paragraph that starts after the proposed opinion was published for comment. We received criticisms of the conclusion. I was just wondering, were all of the criticisms from members of the state bar?
I think all the ones, I believe so.
I think so too.
I do 3. And so I was wondering if it made sense to acknowledge that the public was not complaining, but the lawyers were complaining. I don't know. Just a thought.
I guess to me, that was just implied that it was the legal community that was commenting, but.
Okay.
Is there any?
And I do think at least one of the criticisms we got, it was from lawyers, but they were writing on behalf of like Google or one of those services, if I recall.
I think that might be right.
Yeah.
Does it, I mean, what do y'all think? Is there a purpose? Does that serve a purpose to add that?
I don't think so. I just wanted to say it out loud in case there was a purpose, but I couldn't decide how I felt about it.
I have always assumed that, in half of these proposed opinions, there are criticisms from outside the legal community. I've never sat down and sort of looked at it in that context. But am I accurate about that? That there are? I'm not accurate about that.
I don't think so. I mean, sometimes, if there's a company like LegalZoom or something like that, but I guess, the advertising opinions might be the only time that there is. If it's affecting a business interest of somebody other than a lawyer would be them.
Right.
Yeah, I don't recall any just any general member of the public that has commented, but outside the legal community, it's usually business related and directly impacted by the opinion.
Who did you think was commenting, Ripley?
Given that it's the internet, I just figured it would be anyone and everyone, people from Manitoba, or just, people who are looking to grind an axe, or just, people who pay attention to things. Like Brian was saying, somebody with a business who has legal counsel, or, people who pay attention to stuff. I just figured that it was not infrequent that there would be commentary from outside lawyers or from outside the bar.
So far, people haven't been that interested.
There's
right,
hope for us all then.
Yeah, well, it doesn't change anything, so let's ignore it. I'm sorry I brought it up, but I'm going to do it again. On the 3rd paragraph from the end, in the paragraph that starts, if phone calls are being ethically managed, such appointment setting phone calls should neither create a reasonable expectation of privacy nor delve into sensitive information. And I was wondering if sensitive information was the right word. And if it wasn't the right word, what would be the right word? Because I was thinking, in lots of cases, I have a problem and the problem is X. X is sensitive. And so I didn't want us to be saying, if somebody's problem is a sensitive problem, by finding that out, we weren't ethically managing our phone calls. So maybe I'm just being neurotic and hyperly vigilant over word choice, but that sensitive thing, particularly since I'm a family lawyer, so everything I do is probably sensitive.
No, I think you're right. we really want to say that it doesn't delve into any information.
I was
So
wondering,
no, I agree. Sensitive is not a good word there.
maybe
Detailed.
Detail,
or-
I was thinking maybe.
I was looking at this with an insured earlier today about what you can, maybe we could tie it to something like shouldn't seek to get any more information than necessary to do a conflict check or something like
Exactly.
that, which is, kind of under Rule 1.6, comment 17, it allows you to discuss a client's identification and just enough about the matter in order to determine whether there's a conflict of interest without it being deemed a disclosure of confidential information. I think that might kind of send the message that on that appointment making call, you need to be very careful not to get much of any information other than contact
we
information.
talk about that a bit in the next sentence, but referring to Rule 1.18. But yeah, I definitely think that's not the right phrase to use.
So maybe we could say, nor delve into information beyond that which 1.18 prescribes, something like that.
Okay.
And then you can define it. Or the information that reasonably appears necessary for purposes of scheduling the call or whatever.
Yeah, I can see that.
And so the last thing that I have is in the next paragraph, the last sentence says, for example, lawyers may want, we're missing a T-O, between want and instruct.
Ripley, how'd you miss that? Lazy.
I'm gonna turn in my card right now. Apologies to everyone.
But other than that, I like it. I think it does exactly what we wanted it to do. And so I have no further comments. Does anyone else?
Really good, Suzanne. I appreciate your hard work.
Yeah,
I liked it. I thought it addressed everything that it needs to address without, boxing us in with the opinion. So I liked it.
I'm waiting for Lamar to take off to chew on his glasses.
I'm not going to chew on my glasses today. My training is to be hypersensitive to being.
He almost took them off.
I almost did.
Yeah.
Almost did. Then I thought about it. My father, who I practice with, has beat it into me to be as brief as possible and succinct as possible in my writing. And I see Brian laughing. And so and it's very well done. My reaction is maybe a little long, but if nobody else thinks that, that's probably just me because of how it's been beat into me. But as far as specifics, the only other thing I would say, because you guys really, sort of went at this with a fine-tooth comb, and my takeaways are more general in nature. But one specific thing is there's no page numbers on it, but the second page, second full paragraph beginning after the proposed opinion. And when I'm reading this paragraph, and really the second sentence that begins more specifically, isn't the issue not the recordings themselves, but rather the privacy policy that governs those recordings? And so shouldn't we be a little bit more precise with saying, for example, change that second sentence to say something like, more specifically, we received criticism that the privacy policy of the recordings at issue in the inquiry, and then add parentheses, allowing disclosures of recordings to certain third parties, close paren, are indistinguishable from the privacy policies of communications that are retained by numerous other internet services and applications. And then after applications, add close paren, which also allow disclosures to certain third parties. Did anybody track that at all?
Lamar, I think that's really good.
Yeah, I did too, actually.
I do.
I'm going to make that change.
And here I am saying it's too long, and yet I'm saying add stuff.
Yeah.
But I had my glasses off.
Okay.
She
Yeah, I
was
see
chewing
that.
on her glasses. You missed
See
it.
that. So you must be a really esteemed professional then, and scholar.
No, I think that's absolutely right, that it's the privacy policy.
Yeah.
I kind of, yeah.
I would consider maybe putting your block quotes into footnotes, just a stylistic preference, but maybe something to think about. And then at the end,
She's trying to fill up space in the bar journal, dude.
Okay.
That's actually probably true.
okay, maybe that's what it is. Well, if you're trying to fill up more space, then maybe a summary paragraph at the end. Here I am again violating what I'm saying to adding, but.
What were you going to say before? Was that what you were going to say?
What? Just about? I'm not following.
I think you had another point.
Yeah, that's what
I did.
Yeah.
Oh, what was my other point?
think we interrupted you.
You mean me? Footnotes. Did you say that?
Oh, yeah. I was just saying, consider, because you got like 2 or 3 pretty decent block quotes in here. Maybe consider putting those in footnotes somehow to whittle it down a little bit. Just a thought. But other than that, I don't know. I thought that the way you ended up, it just sort of ended abruptly. Maybe one more sentence to sort of wrap it all up might be a good idea.
That was the other point you were going to make.
Yeah. That's about it from my end. Great job, though.
So make it shorter, but then add all that stuff that you just said.
Yeah, that's right. And, I mean, look, it is hypocritical of me. I don't have time to go through and redline and cut stuff down. But I don't know, maybe just one more pass at it to ask. And everybody else seems to want to add stuff, me included. So maybe I'm wrong, but I'm sitting here thinking, are we going at it as if we're drafting a FEO when really what we're doing is drafting an article for a magazine? But I get it. The audience is a legal audience, but still we're pretty impatient people too. So just a thought.
What is that saying? Consistency is the hobgoblin of little minds.
There you go. And I don't know what an Oxford comma is, so you guys are smarter than me anyway.
You're
It's
too
a
young to
foolish
know what an Oxford
consistency.
A
comma is.
foolish consistency.
A foolish consistency is the hobgoblin of little minds.
I like just consistency.
There's a good argument for that in a lot of ways. Absolutely.
Well, Lamar, I like to make things shorter, and Brian likes to make things longer.
Okay.
So anything in here that's probably unnecessary was probably added by Brian. And
Easy.
if you have some specific passages that you think we might be able to do without, I would love to hear about it.
Well, I wish I had time to give you specifics, but I don't know. When I see sentences that contain more than 2 commas, whether they're Oxford commas or not, I start to get the hives. But anyway.
So I do too, but and I usually do try to find things to take out. And I did go through here looking for that, and I couldn't find anything, because I think understanding the history of this issue is sort of incumbent on where we are right now and how this is going to keep happening. So anyway.
And I'm fine with that. I defer to you guys. If nobody else sees anything in here that you say, yeah, we could probably take that out, then I'll defer to the group on that.
I mean, I'm happy to take stuff out if anybody else sees stuff they think is superfluous, then let me know or
Well,
say
the
it
fact
now.
that this is like the 7th meeting we've had on this indicates that there's a lot going on. I mean,
Exactly.
so I didn't feel like there was any fluff or, stuff just going off on a tangent or whatever. I mean, this is a complicated issue, and we spent a whole bunch of time talking about it, and it ain't over. So, I mean, I feel like, you could write another 800 or 1,000 words about this without a lot of drama.
I couldn't. Brian
Yeah,
could.
you could. Of course you could. But
Brian could.
it's an appropriate length and covers all the stuff we've been talking about appropriately, I think.
Yeah, I agree.
I
I do
agree.
too. Okay, Ms. Brocker, do you have anything to add?
I'm a fly on the wall.
Okay.
Thank you.
All right. So Suzanne, what next?
I will make these changes and send it out to you guys. And then I guess the suggestion, Gina, you'll suggest at the meeting that the committee suggests doing this article instead of doing a formal opinion.
Yeah, I would say procedurally, Gina, you would probably make a motion to withdraw, not withdraw the opinion, but withdraw the inquiry. And I think if there's one other thing that I wanted to add was either a sentence or even just an introductory, like a sentence, in italics or whatever, that's not a part of the substantive article, that essentially says that this opinion was originally published on such and such date following publication and in consideration of the comments, the ethics committee withdrew the inquiry. Just to clarify for everybody that, especially those that read the opinion and thought the ethics committee is about to issue something about Google local service ads and all that, we need to make it very clear that that inquiry has been withdrawn, and this article serves as the ethics committee's statement on the issue.
Got it.
That'll just make it a little bit longer, Lamar.
Gotta scroll
Okay.
over to the next page.
All right. Well, I think we have it. Unless anybody wants to talk to Lamar some more, let's be done with this.
Thank you to Suzanne for all, I mean, you obviously put a lot of thought and work into this with all these meetings, everything else. So thank you for that.
Ripley, you don't have to say that.
Absolutely agree.
Agreed.
It's unanimous.
All right. Everybody take care, and we will see each other in person in a couple weeks.
Thank you,
Yeah.
everybody.
Uh-huh.
Thank
All
you.
right,
all.
bye.
See ya.
Nice.